Okay, well, welcome everybody. This is part of our regular webinar series, and today's topic is making sense of international IP. So to talk about that, I have two experts, one from Europe and one from the States, who are going to spend a little time breaking down for us what the patent process looks like in those areas, how startups can really take advantage of that, and you'll have time for your own questions as well to get a little bit of a personal touch as well. So I'll introduce Barry first. Barry Purdy is a co-founder of Purdy Lucy in Ireland. Barry has a primary degree in biochemistry from Trinity College Dublin and a postgraduate diploma in food science from the University College Cork. Barry has over 20 years experience advising clients on intellectual property matters, including 4 years as an in-house patent counsel in Unilever and 6 years as a senior attorney in a UK private practice. During this time, Barry has advised clients in relation to cases before the European Patent Office Boards of Appeal and Enlarged Board of Appeal and the UK High Court. Barry specializes in patent drafting and prosecution and intellectual property transactions in biotechnology, life sciences, food science, and medical devices. His areas of expertise include patenting human therapy and biomarker-based inventions, functional food ingredients, tissue engineering constructs, and diagnostic reagents and devices, and as well as advising clients on patent infringement and validity matters. His portfolio of clients include Irish universities, Irish and U.S. medical schools, and Irish and European SMEs. That's Barry. Brian Van Osdol is the founder of Alpine Patents, which he founded in order to establish an approachable patent firm, which would put startups first. Brian started as an engineer, and after completing his bachelor's in electrical and computer engineering at Rice University, where he focused on semiconductor devices, he completed his master's in mechanical engineering at Stanford University, where he specialized in mechatronics. He later enrolled in Stanford's computer science master's program, specializing in user interfaces, until he left to become the first technical hire at an early-stage startup. Brian leverages his deep and diverse background in engineering, product and business development, and patent law to bring a fresh perspective to patent strategy for technology startups. Brian has experience building patent portfolios for startups in many fields, including hardware, software, web platform, consumer electronics, clean tech, Internet of Things, manufacturing, user interfaces, medical device design, computer vision, and robotics. So that's plenty of stuff. We really have quite the expert panel here today. So I'm going to run through a few of my own questions, and then, like I said, for everyone watching at home, you'll have a chance to, in the Q&A feature of Google Hangouts, drop your questions, and I'll make sure those get to Brian and Barry as well. So I'll start maybe with you, Barry, and then we'll turn over to you, Brian. Can you guys describe a bit of your own background and interest in IP and patent law? What do you find interesting about it? How did you come into it? And kind of what brought you to it?
Well, I kind of fell into it by accident. I was finishing up in college in 1993 in Cork, in University College Cork. I'm looking for a job, and there weren't very many opportunities. I was given a chance to start in a patent practice in Dublin. The financial controller of the firm was putting together a football team, and he wanted me to play on the team, so he gave me the opportunity of a start, as they call it in Ireland. So I stayed there a couple of years, and then I moved to the UK to work in Unilever's patent division in Merseyside in the UK. And I finished my training there, and I qualified as a European patent attorney in 1999. So before getting into the profession, I obviously had a background in science and biochemistry and in food biotechnology, but I had really no knowledge of patents or intellectual property. So the first really I heard of it was when I was offered the job. So after working in the UK in 2000, I moved back to Ireland and worked for a firm in Ireland, a private practice firm, and then set up my own practice in 2005, and then formed a partnership with my partner here, Michael Lucy, in 2008, and we've been growing the firm since then.
Great.
Yeah.
How about you, Brian?
Yeah, so somewhat not exactly a similar story, but I also didn't really expect to be working in patent law myself when I was at school. Always thought I'd be an engineer. Did several internships, worked at a couple early stage companies, and what always interested me on the engineering side was working on new concepts and helping worked on several design teams where we were kind of thinking of like what is the next version of the company's product, and that always really excited me, like kind of pushing the envelope of innovation and technology. And with my background, I kind of always enjoyed learning about different areas of technology. So once I kind of worked in electrical engineering, I thought that was interesting, but it kind of exposed me to other areas. Went on to do my master's in mechanical engineering, kind of learning about new things. And so I love the diversity that engineering provided. And towards the end of my graduate degree at Stanford, I took a couple classes in IP. I took the first one just kind of somewhat on a whim. Found it kind of interesting and fascinating, the complexities of trying to capture what an invention actually is and write that in paper and kind of the brainstorming involved in that process. And so then I ended up taking another one, which eventually led to my first job in patent law at a law firm, where I started there in 2008. That firm itself also had a kind of very startup-focused approach, and was doing that for several years. And at the beginning of this year, I had already been interfacing with many of my clients, just kind of handling the full process. And I felt like there was like another step that I could take that I wasn't able to offer at that law firm, so started Alpine Patents, and much newer firm than Barry's, but trying to provide high-quality service to my clients, and building that client relationship is something that I really enjoy, and interacting with people and hearing what people are working on, I always find very exciting.
Cool. And what are, Brian, what are some of the most common types of cases or projects that you handle? Startups, I think, are a big part of your business. How do they fit into your process, and kind of where do you see them coming from? The most common cases you have that maybe you see across the board, or that specifically come from startups?
Yeah, so I pretty much exclusively focus on startups. And many times when people come to me, they come at various stages of their fundraising stage, but usually they come when they're kind of beginning their patent portfolio. So they have gotten guidance that they need to investigate IP and build some sort of patent portfolio, or they just know it's like part of what investors are going to be looking for, or they don't understand it and they just have questions. And so a lot of times when people come to me, that's where they're coming from. Is they are wanting to build a patent portfolio and they haven't gotten started yet. And I kind of help, I guess, guide them and identify what makes sense to file first, and how do you grow that patent portfolio so it stays in check with their fundraising and their products and their technology development. And then the other portion of clients, I guess, probably smaller, are ones that perhaps weren't as happy with their previous counsel. It's usually still early in the patent portfolio process, and then helping them kind of understand what a strategy might look like based on their earlier filings, and kind of adjusting that. And then, I guess in terms of the clients, a lot of them are early stage, so kind of beginning the relationship when they're seed round or pre-seed, and then helping them grow to larger companies. My largest client that I started at my old firm and continued doing work outside of at Alpine was Twilio, which was they're a software-based company, but they started off as 3 people with an idea. No one knew about them, and now they're one of the billion-dollar unicorns.
Right.
And so it's kind of seeing the full range of like what startups need, and kind of helping them keep their IP in check with what makes sense.
Cool. And what about you, Barry?
Yeah, something similar to Brian. We would specialize particularly in handling university work coming out of Irish universities, and then universities in the US as well. We'd handle cases for some of the East Coast universities, Mass General Hospital and Tufts. And then a lot of those technologies that we work on in the university setting, when they get spun out into companies, we would often continue the relationship that we have with the PI, and then work with the company. So I guess we've developed over the years a bit of expertise in understanding startup companies, and I guess the problems and the limitations that they have in terms of where they are, and funding issues. And we try and tailor our service to give them the best possible IP service, and work with them as they're developing. So we'd work with a range of companies between myself and my partner, who is an electronic engineer. We would handle different types of companies. For example, companies dealing with scaffolds for healing bone defects, companies dealing with biofilm reactors, fluorescent probes, or bioactive food ingredients. Quite a large range. The other types of technologies that we would handle would be medical and biotechnology-based inventions, and handling them from initial filing stage to international filing, and then to the national phase stage. One of the things we try and do with our company.
And maybe you can talk a little bit about.
I see you, Barry.
Have we lost Connor there?
Yeah, I think so.
Okay.
I don't know about anyone else.
Oh, sorry. I think we might have dropped out for a sec there.
Okay.
Sorry. So Barry, I was just going to ask, maybe if you could talk about, maybe describe from the Irish perspective what a startup should be thinking about IP.
You kind of broke up there.
Oh, sorry.
Again. I don't know if you can hear me.
Yep, I can hear you. So I was just asking, maybe, can you talk about the process for a company, maybe an Irish company or a European company that wants to protect their IP? Where do they start?
Yeah, so I had a good think about this question, and I thought I had the answer, and then I thought about it a bit deeper, and thinking at it quite a high level, and we do this exercise with clients sometimes, is confidentiality is a very important issue in companies that have employees that are inventing, and they need to understand the rules that the company have regarding confidentiality. And then it's also important that intellectual property is identified, because if it's not identified, it's not protected and it can slip out. So I think one way of dealing with this, and it may be for slightly larger companies, but there's no reason why startup companies cannot do it, is to document some form of IP policy right at the beginning, and just make sure that all the employees and the directors are aware of the policy and they sign up to it when they enter the company. And what would that policy say? I think it's important, that employees know what to do if they have an invention or if they have some new technology, how to notify the company of it, that there's some sort of procedure. I think it's important that they understand about ownership and who owns the technology, and then also around about confidentiality, because if you wish to patent something, certainly in Europe, and it may be the case in the United States with the new America Invents Act, but it's important to keep technology confidential, or inventions confidential, before you file a patent application, because if you disclose it before you file a patent application, you can prejudice your subsequent patent rights. And then there's also a whole issue around, patenting is one way of protecting IP and technology, but another way is keeping it secret. It's also called know-how or confidential information. So I think it's important that companies have procedures around know-how and documenting it, because it's something, if it's an important part of a company's technology that's not patented but you're keeping as confidential know-how, it's the sort of thing that would come up in due diligence with investors, that they'd want to know how you're safekeeping your know-how and how it's documented. So the other issue would be employee contracts and IP terms in that, and those sort of issues.
And are there any, and maybe Brian, you can jump in here as well if this is different in the US, but are there any formal protections around know-how? Is know-how something Obviously, you keep it secret, but is there any sort of, if there was a breach, a security breach or a breach of trust or something with a co-founder, is there any protection there from know-how? Or is that something that's very, it sounds ephemeral to me.
Who do you want to answer that? Barry?
Do you want me to answer that, Connor?
Situation. Barry, I was just asking about protecting know-how.
Yeah, so in Europe there isn't any way of protecting it. So I mean, what is know-how? It's information that has a value and is not in the public domain. That's the definition of it that we would use when speaking with clients. And by definition, that once it's disclosed and it leaks out, it is no longer know-how and it loses all its value. So there's no formal ways of protecting it. And that's why it's very important that companies have policies and procedures regarding how it's protected, and that that information is made available to their employees through contracts of employment, through an IP policy, and then potentially also through entrance and exit interviews when they're coming and going from the company, just so that they're made aware of information that they may have had access to during their employment. That is not to go out the door with them, if you know what I mean.
Right.
And the situation is pretty similar in the United States. I guess in the United States we refer to them as trade secrets, and once that becomes public, it's public information. There's no legal safeguard to kind of pull that in and have that protection still. There is like this notion of reasonable safeguards that you apply to your trade secrets, and so there could be action against the person who leaked the trade secrets, but usually that's that involve like a lawsuit or something like that, and you're only getting damages against the theft, I guess, of those trade secrets, but not necessarily getting protection of preventing people from using those trade secrets, because it's once it's been leaked to the public, it's kind of
it's out there. Yeah. Cool.
Exactly.
Interesting. So what are some of, and I think this is kind of the heart of what today's top conversation is about, what are some of the kind of key mistakes or pitfalls that startups make when they're first trying to just get a handle on their IP? Let's say they've been up and running now for a few months, maybe 6 months, maybe even 12 months. What should they be doing from day one that they probably haven't? What's something that, once they're gaining some traction, they want to make sure they have done? Just talk us through that process.
Yeah, I mean, I guess some of the big mistake, I guess, is somewhat, and it's very common, is for thinking about IP at the last minute. Many companies, they are working, and it's understandable, they're working on their product, they're working on a million different things, hiring, marketing, business, fundraising, and they're about to be announcing something or launching their product, and then the question of IP comes up, and sometimes that's when new clients come on board, is right before they have that public disclosure, which is great, rather than after the public disclosure. But even like existing clients, that sometimes can happen. And so I think having a good handle of what your IP strategy is ahead of time, and just kind of, you don't have to, shouldn't take too much maintenance if you're just getting started, but being able to check in and be able to identify what you want to protect with a patent, being knowledgeable of what IP that you filed previously, what it does protect, and allowing you to kind of know, like, all right, we've developed this new product, our patent doesn't really cover this aspect, so we need to at least have the discussion of should this be protected in a patent or a provisional filing, at least. I think that's one of the big mistakes. I mean, I think Barry touched on a lot of other issues with the IP policy. A lot of startups work with contractors, and so especially early on when it's just kind of the founders, and maybe they haven't actually found like the full founding team yet, and they're working with several contractors. Sometimes people have to go back and kind of get the IP licensing and assignment kind of corrected after they've already been working with the contractor, and so being to think of that ahead of time, I can avoid a lot of headaches
Yeah,
sometimes.
they're probably exposing themselves to some risk. Yeah.
Mm-hmm.
Do you have any thoughts on that, Barry?
Yeah, I completely agree with everything that Brian said. I think one area we see sometimes with early stage companies getting into difficulties or potentially getting into difficulties is with this whole area of freedom to operate, which is really it's an exercise to try and minimize the risk of infringing other people's patents. It doesn't really have anything to do with you patenting your own technology. I guess it's more to do with making sure you're not going down a one-way street in developing a technology where you'll never be able to launch it. And it's something that I think comes up in due diligence with investors who will ask the question when they're looking at your company to see whether you have looked into that issue at all, even in a quite preliminary way. So it's something that we always recommend with startup companies before sort of A-round funding, that they do some freedom to operate assessment and try and get an idea as to whether there's any major patent barriers in the way, which would either prevent them launching a product or require that they change the product a little bit or change direction a little bit.
And maybe on that topic, are there good resources when you're just starting out to kind of for teams that want to educate themselves on IP and patent law? Like where would you turn if maybe not ready yet to patent something, but you want to understand the process? How do you go about navigating resources? Maybe Barry, you can talk about the European side of things. And I don't know if there's probably totally different resources available, Brian, for the U.S. But what are some kind of the easiest ways to get yourself a bit more fluent in this language?
Yeah, I think there's a lot of publicly available resources that are available. So for patents, for patent IP in Europe, there's a number of websites. European Patent Institute is quite a good source of information. And then the CIPA website, that's CIPA in the UK, which is the Chartered Institute of Patent Attorneys. They provide a certain amount of information to the public. I think also, your own patent advisor would probably be happy to sit down and talk with them, without charging. During, for example, an initial meeting, just to give you an idea of the procedure involved, the timings involved in filing patents. It's not a rubber stamping process. It takes a long time to get a good granted patent, and it's quite expensive as well. So they'd be quite good sources of information. And I think it's important for technology companies to have someone who is familiar with patent search engines and being able to search patents, because it's my experience with PIs is that they're quite knowledgeable of the academic literature, but the patent literature is often full of surprises to them. So the more familiar they are with that, the better position they will be in to identify valuable IP and to help their patent attorney and work with their patent attorney.
Yeah, do you have thoughts on that, Brian?
Yeah, there are several kind of public. Searching on Google for whatever your question is might be the best way. But the U.S. Patent Office actually has a lot of great resources for inventors. And if you even are kind of very early stage and you're wanting to get like a provisional in place before you even talk to someone, a professional, to kind of help you with the application or coming up with a strategy, they're actually very helpful just calling them up on the phone if you are having troubles understanding what you need to do. I've had people take that approach, and they've said it's been very helpful. I think the other thing, just adding on to what Barry mentioned, is I think that the first thing for people to understand is like what is the process of getting a patent, and like what are the documents that are going to be filed, what's the timeline of those different documents. And so I guess it isn't going to be a rubber stamping process. There is kind of this, there's multiple stages to it, and there's each stage has its own kind of unique properties and like when you would use it and how it's going to impact your patent. And so understanding that, I think if you can wrap your head around what that process looks like, that's going to help you tremendously in talking to a patent attorney and understanding, all right, this is what the next stage is going to be, and setting up those expectations early on.
Right, right. And maybe what are some of the best ways when you're talking to advisors? I know for SOSV teams, we're frequently putting them in touch with people that we trust. But aside from just name recognition or referrals from friends of friends, are there qualifications that you can ask to see from someone who works in patents, or is there some way to filter kind of who's a useful patent resource for you versus who's just Joe Schmo off the street?
Yeah, I mean, I think looking at their background and seeing that they do have a focus in the technology and the type of clients that you are, I think other key factor is if they do spend the time when you talk to them and they're kind of do take a strategic approach to how they're approaching not just the one patent that you're filing, but your whole portfolio. Mm-hmm. There are people out there that you can find and you can send them information and they'll turn it into a patent. But I feel like a good advisor would be able to kind of look at that, give you guidance on whether that's something that makes sense to move forward with. If you kind of explain all your technology to them, there should be at least a couple of things that you're like, hey, we shouldn't focus on this. This isn't, you're not making money on this. This technology's probably not going to be important to your company in 2 years. And so let's focus your IP protection on these assets and these other ones. It's just kind of how you're entering the market.
Cool. Yeah. Maybe Barry, in the European system, is there something different there, or is it much the same?
It's the same in that there's a qualification. I think the difference between the patent attorneys in the United States and patent attorneys in Europe are that in the United States the patent attorneys are actually what we call lawyers, who would have a technical background as well. Whereas in Ireland we're not legally qualified. We would have a technical background. So I have a degree in science. My partner has a degree in engineering. All of our patent attorneys in our firm would have a technical backgrounds, and then you train in a firm, and after 3 years or 4 years you sit your professional exams, and then you're certified as a European patent attorney. Mm-hmm. Unfortunately, in the firm that I trained in, we also had to become chartered UK patent attorneys as well. So we have another 10 exams to sit apart from the European exams. So they went on forever. But I think what's very important for any inventor when they meet a patent attorney is A, that the patent attorney is qualified and competent, and B, that they kind of understand your technology, because they could be the best patent attorney in the world, but if they don't understand your technology, then they probably won't do it justice in terms of describing it in a document. So I think they're probably the two most important things.
Mm-hmm. And Mary, you touched upon this a little bit just now, kind of describing the different system for exams and solicitors versus attorneys and things like that. What are, you work across Ireland and the US, Ryan, you spent some time working with teams abroad as well. What are some of the maybe big differences that teams, especially teams who have a presence in multiple markets, should be aware of in terms of the differences between patent law in the US and patent law in Europe? Are there kind of major distinctions or major differences, or how much of it kind of syncs up?
I think they're kind of getting a little bit closer. Brian, you probably confirmed this in a minute in terms of patenting software. I think that the US is maybe becoming a little bit more like Europe in terms of the challenges in patenting software, computer implemented inventions. Just in my own area, in the biotech area, for a long period of time during the 80s and during the 90s, it was quite unclear in Europe what you could and could not patent in the biotechnology area. Whereas in the United States it was fairly clear and it was established. In the last 5 years, that has completely changed on its head. In Europe now, it's clear what we can patent, and those patents are valid in most of the states in Europe. But in the US, it's becoming very difficult now to patent inventions that are based on biomarkers, so methods of diagnosis or methods of prognosis, which rely on some sort of biological diagnostic variable in the body. And another area of difficulty in the United States at the moment is patenting so-called natural products. So an example of it would be a genomic DNA, and this came from a number of patents owned by a company called Myriad Diagnostics in Utah. And one of their patents, or 2 or 3 of their patents, I think, ended up before the US Supreme Court in 2013. And a lot of the claims in the patents were revoked, particularly the claims to genomic DNA, natural products. And the fallout with this is that now it's extremely difficult, if not impossible, to patent products that exist in nature. Examples would be genomic DNA, proteins, bacteria. So one of our clients, where you're based, Conor, University College Cork, have a big research base in probiotic bacteria.
Right.
And they will have difficulties patenting those bacteria in the United States. Now, it doesn't mean that they can't get patent protection, but whereas before they would be able to obtain claims to the bacteria themselves, those claims could stop anybody making, using, or selling that bacteria for whatever purpose. Now they have to limit the scope of their claims to particular uses of the bacteria. So, for example, the use of bacteria X to lower blood pressure. So it's becoming a challenge in the US, this whole area of patent ineligibility. It doesn't seem to be happening in Europe yet, but who knows, in future the European legislators may decide to follow suit. And I know, I'll hand over to you, Brian, now. I know in the whole area of abstract ideas and business methods, there's been more case law on that in the United States.
Yeah, so there are several cases. That's probably like one of the biggest things when approaching my clients' approach to filing internationally. Most of my clients kind of take a U.S. first approach to their patent filing, and then it's kind of like, does it make sense to take it internationally? And especially for clients that do have a software aspect to them or have particular patents that are more software based, generally don't take those international, just because most countries don't look at those concepts as favorably in terms of patentable subject matter. And then within the United States, that's also becoming somewhat more questionable. There's been several cases that came down calling into question, is software or business methods patentable subject matter? And it's still a little unclear what is going to be allowed in the future. My personal opinion is, I think the United States, just because people and large companies have devoted a lot of amount of money to building up IP in this space, I think there will probably always be some level of protection for software that's tied tightly to technology. It seems like the courts are really coming down harder on business methods, so these are kind of like patents that try to claim ways of doing business, of how fees are transferred around to different entities, and how you charge customers. I think those have been hit pretty hard, where they're no longer as interesting to even pursue software if it's something that is very tied to some computer architecture or unique way of, I guess, operating technology, and it's kind of a step away from just kind of describing steps that a human can perform. Right now, that those are still able to get things issued in that side, but as it becomes kind of these very generic steps that you try to then say, we do this on a computer, the made-up example I sometimes use is like the process of I don't know, maybe in the early 90s, wouldn't be too surprised to see some patent that kind of in the United States where it's talking about measuring a shoe size and then suggesting a shoe color and then recommending a final shoe product, and then you do this on a computer. And something like this, which most of the steps are very generic and kind of just things a human would do, but then they somehow tied it loosely to a computer. Patents like that were being issued, but hopefully not that egregious. That's something that I think the courts are trying to make sure that those patents definitely aren't allowed in issued as patents. The other key difference between the United States and pretty much every other country in the world is that the United States does allow a grace period, and so if you do publicly disclose, most countries you've sacrificed a lot of your IP rights, but in the United States, at least, you have 1 year to get provisional or an application filed before that, after you've already publicly disclosed. So you are allowed this 1 year grace period to have something on file with the Patent Office. The other big change, the United States is kind of moving more towards a system similar to the rest of the world. Before there was this first to invent versus first to file. The United States had this first to invent where you could keep a lab notebook and show that you invented this previously, even though you didn't file anything. But now that's no longer the case. We're in the first to file, like Europe and the rest of the world. And so what this really has changed is getting something filed before you publicly disclose, and making sure that you're filing as fast as possible so you have something on is just that much more important, because you can't rely on notes and evidence that you invented this concept before your competitor or someone else.
Right. Are there similar trends like that taking place in Europe? Very.
In terms of the first file, first to invent thing, well, that never applied in Europe. In Europe, it's first to file, and I think in most countries in the world, it'd be first to file. So this is why it's so important to keep your technology confidential before you file a patent application. If you're interested in getting patent protection in Europe, I mean, if you're based in the US and your market is in the US and you're not interested in patents elsewhere, then there is the opportunity, as Brian outlined there, to for the inventor to publish his technology and then file a patent application within 12 months of the publication.
Mm-hmm. And what recourse do you have, especially if you're a startup with limited means? You know, I hear a lot about patent trolls, for example. You know, are there ways to deal with them? I mean, presumably, if you're an early stage startup, you're keeping your work fairly confidential. But you know, if you do come across a situation where you realize that a patent that you've either been working on, but now that in the system of first to file, you kind of lost the race. Is there any recourse there for you? Or is there any protection? What should you do in that instance?
Yeah, patent trolls are a difficult thing. I mean, I don't have any. Luckily, my clients haven't had any dealings with them. Mm-hmm. But I know some friends of mine who act for clients who have had dealings with them. They're probably to be avoided at all costs. Sometimes you can't avoid them. How do you avoid them? There are certain things you could do. One is doing patent searches, what I call freedom to operate assessments, and doing them early and often, and to try and, as in line with your patent strategy, try and set out a roadmap of technically where you're going, and try and make sure that that the path of the route is free of third-party patents. That could help. I think another thing is developing your own patent portfolio. This can help insofar as not only in protecting your technology, but it can have a prior art effect and prevent these patent trolls on subsequently filing patents themselves with very, very broad, overreaching claims.
Right. And what's that? What was that term you just used? Was that prior art? Is that what you said?
A prior artifact, yeah. It's just when you file a patent application for something, 18 months after you file it, it's published, and the effect of the publication is that some third party can't subsequently file a patent with. Well, they can, but they can't validly get a claim which covers technology which is already in your patent, published in your patent application. So yeah, that's really the only two pieces of advice I could give on that. Yeah.
What about you, Brian? I feel like the Valley might be a more high octane place when it comes to that sort of thing.
Yeah, I mean, patent trolls are tricky. Usually when we talk about building a patent portfolio, like having your own patent portfolio can provide a defensive measure against competitors who they may not sue you because you may infringe their patents and they may mutually infringe some of your patents. So it's kind of this mutually self-assured destruction scenario where your competitors and yourself don't sue each other for infringing patents. But for a troll, they're by definition someone who's not practicing their product. They just have a patent on it. Usually, sometimes these are patents that come out of failed startups or failed endeavors by solo inventors. They're trying to make some money off of their IP and they sell it off. And many of the people buying it are these patent troll companies. And they're basically businesses that go around identifying people that infringe patents and then suing them. They often kind of go and they'll target companies that kind of multiple companies infringe patent, and then they'll just go down the list trying to get as much money from everyone. So it's tricky because there's not very much action you can take against them. There's been, I don't know, around 2 clients that I can think of that were kind of hit by a troll, and the way that it was handled was basically paying them some amount of money, which is painful, but getting involved in a lawsuit is much more painful than trying to disqualify that patent or fight and say that you do not infringe. They kind of also will look, like you might see Apple being sued, and for one of these examples, like Microsoft or Oracle and all these large tech companies were kind of you could look up their patents and you can see that they had notified all these different clients or different companies. And they're looking for much more money from those companies versus some small startup that they just happened to see had some fundraising event on TechCrunch. Right. So, I mean, I think very early stage, it's less of a worry because you're not in the news very much. If you do have a very popular Kickstarter campaign, maybe that gives you more exposure, unfortunately, before you actually really have the money coming in. So, I mean, as much as you can avoid them, that's probably the best approach. There are new things coming out. There's a company called RPX, which they started, I think, like 5 years ago, or maybe a little bit more than that, and they started basically a service where for large companies you could buy into their service, and they kind of add this layer of protection, and it's kind of like it's almost like insurance, where they kind of will purchase up patents off the market so that they don't enter the hands of trolls, and they're trying to do other things of disqualifying patents and things like that. Before, that service was mostly for large companies, Apple, Microsoft, companies like that, pay them several $1,000s, maybe $1 million. Like they give them a lot of money to kind of be part of that. And recently, I haven't gone into the details, but they've begun to look at startups as another channel and offering, obviously, cheaper kind of this patent troll insurance. But I have yet to have a client that used that, but it may be that in a few years there's products like that that might make sense.
Yeah, there's probably a need for it, I imagine. Yeah, interesting. So one thing, when I was kind of educating myself or just doing some exploring, preparing for today, one thing I kept coming across was this idea of claim construction. Every sort of article I read said one of the most important things you need to know about, figuring out your patent law in the 21st century is claim construction. That to me it's a completely foreign term, but maybe you could both could talk a little bit about what that means, what that looks like. Is that really more of a lawyer thing, or is that something that a startup founder can get good at or can become involved in?
Mm-hmm. Yeah, so within a patent, you're going to have several different parts of it. There's going to be drawings, which is usually what people kind of associate with patents, and then there's going to be a written description. But then what actually matters in terms of defining what your legal protection is are going to be the claims. And those are usually some number of, it's a list of different limitations that you say that you have protection on, and they have to qualify. Those are what's actually going to be examined by the patent office, and they're going to be examined for novelty and the fact that they're not obvious combinations of other existing technologies. And if the patent office looks at that after examining it and looking at the prior art, can't find anything that is similar or very obvious, like modifications to get at what you're trying to protect, then you get an issued patent, and those claims come out. It's probably why you go to a patent attorney or a patent agent to help you, because that's kind of it's like this somewhat tricky legal document where you're navigating the law and also trying to define a scope that gives you the broadest description, and also protecting what you're doing while also avoiding prior art and trying to get it allowable. So that's what they're talking about when they're talking about the claims. It is also when you see articles on tech blogs and things like that, and they mention patents, and the writer's kind of upset about some patent that Apple was issued or someone else was issued. They're usually looking at the title of the patent and not actually looking at what the claims are doing, because that's where the legal protection is defined.
Right. That probably fits into when you're researching on your own, when you're kind of going through those generated patent search engines and whatnot. That's probably what you should probably be focusing on, I imagine.
Yeah, so the freedom to operate issue that Barry was bringing up, when you find a patent of your competitor or some troll, you just found it out there, and you look at the drawings, you look at the description, and you're like, oh my gosh, this looks so similar to what I'm doing. Really, to determine if you're infringing it, you would go to the claims and look at, there's usually going to be somewhat of a bullet list of different elements, and if you do everything in that list of claims, of that independent claim, then you might infringe.
Then you're screwed.
And then you might want to talk to someone who might be able to kind of help you understand if that actually is. But if you look at that list and there's there's 10 things on that list, and you do like 4 of them, but you don't do the other 6 things, then you don't infringe because you aren't doing what they're claiming.
I see. Yeah, and is there a similar system here in Europe, Barry, for how patent applications and how they're structured? Are claims is claim construction as vital to the system?
Absolutely, and it'd be very similar. The documents, a granted U.S. patent and a granted European patent would have the same anatomy, in terms of a description of the technical field and the prior art. Statements of invention, descriptions of figures, detailed description of the invention. Mm-hmm. And then at the end of the document you have this section called claims. And I think, it's very, very important for technology companies to understand the structure of patents, because depending on what they're doing, they probably should look at different parts of the patent. So if they're doing a general search of technology to determine whether their invention is novel or inventive, they really need to look through the whole of the document. Not so much the claims, but to look at what is described in the document through the examples and through the statements of invention. But if you're looking from an infringement point of view, just to see what your competitor's patent covers, you really need to look at the claims. I would say at this stage that determining and construing claims is not for a layperson. It's probably best before you make any important decisions to involve a patent attorney in it, because For example, there are only certain claims really that you probably would want to look at. There's also the question as to the document that you're looking at. Is it a patent application, which means that it's unexamined? Is it midway through examination? What are the latest claims that are on file, which are often not in the published document? Or is it a granted patent where the claims have been settled? And then you have to look at the independent claims as opposed to the dependent claims. And kind of once you've sifted through all that, quite often in claims, the claims are like the fence that define the monopoly. That is controlled by the patent owner. So it's very important for people who work in technology companies to understand how to read claims and how they work. And the way you read them is you kind of have your product in one hand and the claim in the other hand, and you read the claim and go through the integers in the claim and try and determine whether all those integers are in your product, and if they are, then there is a risk that you infringe. Quite often, in many cases, though, there will be a curveball in claims in the form of a word which is not entirely clear what it means. And in that situation, and this is where this issue of claim construction comes in. And claim construction means construing the language of claims to determine what it means. And the dictionary, for any word in the claim, the dictionary is really the patent specification, the rest of the document, which should explain what it means. But it can be a tricky process. I remember when I was training as a patent attorney, my old boss put a claim in front of me, and it had about 8 lines in it, and the claim was to a vehicle having 2 wheels and a seat. And he asked me to construe the claim, and I read it, and I said, yeah, that's very clear, I understand exactly what that claim covers. And then he put a picture of a bicycle in front of me and said, does that fall within your claim? And I had a look. It's a bicycle is a vehicle, it has 2 wheels and a seat. I said yes. And then he put a picture of a car in front of me. And is it a vehicle? Yes. Does a car have 2 wheels? It has 4, but that means it has 2. And it has a number of seats, so it has a seat, so that was an infringement. So I thought, this is it, okay, I've got it cracked, I understand patent infringement. And then he put an office chair with wheels in front of me and said, does this infringe your claim? And I had to think about that. If that was a real life situation, the issue would be, is an office chair a vehicle? In that situation, you have to look into the rest of the patent and construe the term vehicle in line with how it's described in the rest of the patent specification. Right. So really that's what claim construction, that's kind of how you approach it. That gives an example, I think, of the complexities involved sometimes.
So, and in terms of infringement, like there's sort of two kind of perspectives you can take to this. One could be, when another company or a patent troller or some other system is infringing on your patent, or if you're trying to kind of play to the margin. Basically, how far can you go with infringement? Is it if there's 10 claims? Is it are you infringing? You're infringing on 9 of them. Has that gone too far? What's the system like for understanding when you're when you've gone too far, when you've infringed on a patent and when you haven't? Is there an easy way to figure that out? Is there
Yeah, it's whether you infringe the independent claims. So if you look at any patent, a U.S. patent or European patent, claim 1 will be a device comprising features A, B, and C, and then you might have claims 2, 3, 4, and 5, and each of those claims will have a preamble that says a device according to claim 1, in which really claim 2 is a subset of claim 1. There's no point really in looking at claim 2. Really what you have to do is look at claim 1. That's an independent claim. insofar as it doesn't depend on any earlier claim. And if you think you infringe claim 1, then there probably is no need to look on the claims that are dependent from it in the initial stages of the exercise. And I think it's important to point out that you could have more than one independent claim. So claim 1 could be an apparatus comprising A, B, C, and claim 10 could be an independent claim to the same apparatus, but worded slightly differently to give it a slightly different scope of protection. So those independent claims that you have to look at when determining risk of infringement.
Cool. I imagine it's a very similar process, Brian, in the US as well.
Yeah, I mean it's very similar. I guess the only thought that I had to kind of add to that might be that when patents are issued, sometimes that should be. Oh, is it muted? Sorry. Sometimes there are patents issued that probably should not be, whether there's prior art of your own that should have been looked at by the patent office, or prior art that was like 10 years old that the patent office just didn't know about. And so sometimes if you look at the independent claim, there is this analysis of, do I infringe? And you look at those different limitations, that bullet list of limitations. But then there's another step, if it does look like you infringe, of is this claim even valid? And if you feel like there was a claim and they were claiming a vehicle with 2 wheels and a seat, you're like, well, office chairs and cars and bicycles all existed, so this claim should be held invalid. And then there's several different options of what you do from there, whether you just kind of keep that knowledge in the back of your head if they ever sue you, or you can take steps to get it invalidated. But after you look at that, then you kind of, the analysis continues, and that's when you would begin to look at the dependent claims. But that level of detail is probably best left to a discussion with your patent attorney, your patent agent, whoever's representing you, because that's beginning to get a lot more complicated to kind of have that analysis.
Right. And so we're also running a little bit short on time, so I want to make sure that if anyone has a question for the viewers out there, if you drop it into the Q&A feature in the Google Hangout, that'll pop up and I'll be able to get it over to our panelists. But so start asking away. But I think sort of my last area for you guys is just, you're working, Brian, in hardware and a bunch of other spaces, and then Barry, you're over in biotech and life sciences. What are kind of the big emerging topics in hardware right now? For example, obviously hacks is a huge part of our program. A lot of folks thinking about that. What are kind of what's the big news in hardware IP law?
I mean, really, I think that a lot of the hardware companies I handle, they still have a software element. So at least in the United States, there is kind of it probably is whether software is going to be protectable long term, and what percentage of software patents are going to stand up, and like what do you need to do to try to protect that. I think that has the largest impact on hardware companies. Even though they're hardware companies, they will have platforms or software that kind of enables their abilities. If you think of Nest, Google's little thermostat, I mean, it is a physical device, it is hardware, but there's a lot of software behind the scenes, how you control that, how you're managing everything, how they interact with each other. And sometimes software, like a few years ago when software was very less questionably protectable, software is actually a great way of kind of getting very broad coverage, because a competitor may not implement the same hardware in the same exact way, and so a system-focused claim might protect them from copying you, but it may not protect. They kind of block your competitor from moving into the same space. And software was somewhat of a way of getting that functionality protection. And so I think keeping apprised of developments in that area may help people, or knowing that you should ask your patent representation kind of how there have been any new developments, how that impacts your existing patent portfolio, how it might impact the growth of your portfolio. That would be good things to ask.
And Barry, what about you? What are some of the big things happening in life sciences? I feel like I hear about 23andMe all the time. What else is out there? What are kind of the stories making waves and the kind of processes or changes to IP law that are really having an impact on kind of the life science spaces, folks working in biotech, DIY bio, that sort of thing?
Yeah, I think from a technology point of view, the whole the gene editing technology that's been developed in Boston and in Berkeley in California, the so-called CRISPR system, is very interesting. And when I was over in Boston in June, it was in the papers quite a lot. I think there's a dispute going on at the U.S. Patents Office regarding a dispute between two patents that were filed by the competing research groups. But it's generating a lot of interest in the scientific community and in the biotech patent community. And there's actually a lot of technologies being filed now for developments and add-ons to this technology. So it's very interesting. Just from a law perspective, what is interesting at the moment in Europe is that there is a new patent going to be available in Europe called a unitary patent, and we think it'll be available in the next year or 2 years. So currently the system in Europe, there's a centralized office called the European Patent Office, which allows you to file a single application that covers pretty much all of the EU, and prosecute it in one central location to become a granted patent. But once it becomes granted, then it becomes a bundle of national patents in all the individual countries in Europe. And the effects of this are twofold. One is that renewal fees have to be paid every year. So instead of paying a single renewal fee to the European Patents Office, when the patent is granted, you have to pay one in each of the individual states where it is in effect.
Which is like 20 something, right?
Yeah, there are 42. I mean,
42.
I think there are 37 or 42 states. And in addition, to validate your European patent in each of those states, in a lot of the states you have to have a full translation prepared. So you can imagine you having Spanish, Italian, Croatian, Polish, Turkish translations. It's terrifically expensive. But what the legislators in Europe have done, and they've been talking about this for years, but it's going through now, is that they're introducing a unitary patent, so that when your European patent grants, you can designate it as a unitary patent, which means it's a single patent. You only have to pay one renewal fee every year, and it's a single patent that will cover the whole of the EU. And another advantage of this is that if you wish to enforce a patent against somebody, under the old system you would have had to sue them in a number of different jurisdictions. Because if you sued somebody in Europe or in the UK, the effect of that decision wouldn't be effective in Germany. But as part of the European patent, the EU is setting up a European patent court in London and in Germany and in certain countries in Europe. And the effect of those decisions of those courts will be pan-European.
Mm-hmm.
So if you want to prevent, stop, and infringe in a number of different countries, you only have to take one legal action. So that's the main thing, I think, going on in European patent law at the moment.
Perfect. That's fascinating. All right, so we're actually just over time, but we have one question anyway. From Alan, who's based in Ireland. His question, but I think it's a question that applies to both of you, is simply, what's the budget a startup should earmark for a worldwide patent registration? Or should they just go for a US registration or EU registration? Maybe Barry, if you have thoughts on that, what kind of budget should they be looking at?
Yeah, so it's kind of a long, drawn-out process. It really depends on the technology. That would inform what markets they try and cover. I think in biotech, I think Europe and US would cover 60 to 70% of the world biotech market, or it would have a few years ago. we would recommend a strategy of filing a European patent application to get a search cost to that, and then filing a PCT a year later, and then nationally filing in Europe and US. Budget over say 4 to 6 years, you get granted European, granted US patent. Yeah, you're probably looking at 50 to 60,000 euros, something in that region.
Wow. Is that similar, Brian, in the US, or what's your
Yeah, I mean, I guess the patent cost of taking things international does increase that budget, I think. Barry mentioned the PCT. That is a way that startups can kind of both. First off, you have to keep in mind that that isn't all due when you do your first filing, whether it's in Europe or in the United States. And so, in the ideal situation, you can kind of build up your patent portfolio in check with how much funding you have. And so, when you're first filing in your first year and you're filing provisional in the United States or filing in elsewhere, like that's kind of like the cost that you have to think about for your stages, understanding that there's going to be costs down the road. And so tools like the PCT, which is a vehicle that allows you to enter different countries, it kind of allows you to push off some of these costs and also the decision of what countries you're going to enter. So a typical scenario if someone's in the United States, that if someone's interested in international protection, you file provisional before you have a public disclosure. You end up converting that a year later, filing that in the United States, and filing a PCT that kind of preserves the right to enter different countries down the road. And then you can use the search results of that PCT and also any prosecution or examination of your U.S. patent application kind of to determine how valuable this patent's going to be. Is it going to be as broad as you thought it was going to be when you're initially doing it, or is it going to be a hard fight to get anything allowed? Just so that you have to consider the patentability of the application, and then you can also think how valuable of a patent is this going to be to our company anymore. Startups pivot and they change quite a bit, and so sometimes even though initially you thought this was like what your business was going to be all about, you'll shift a little bit and your technology changes, or you find a better way of doing things where the patent becomes less valuable, and you have the opportunity to kind of say, like, we don't want to take this international anymore, or we thought we wanted to have a patent in the United States, Europe, China, Japan, India, there's a lot of several countries, but then you might be like, all right, well, it's still important, but it's not as important as we thought, so let's pull back how much, how many countries we're actually going to enter.
Great. Let me just see if there are any other questions. I think that's everything from folks. But so I just want to thank you both for taking part today. Really appreciate it. For those watching at home, I'll turn over Brian and Barry's contact information after this. You can follow up with them with any more questions. You can get in touch with them. But thank you both so much. Really appreciate it. I hope that everyone at home enjoyed it as well.
All right. Thanks, Connie.
Okay. Thank you very much.
Thanks.